We've got breaking news. James Comey's criminal indictment has been dismissed without prejudice based upon a motion that was filed by him, a motion to dismiss for the invalid and illegal appointment of Lindsey Halligan, Trump law lackey extraordinaire, as the U.S. Attorney for the Eastern District of Virginia. If you'll recall, the presiding judge over James Comey's case, Judge Nachmanoff, did a special appointment of another federal judge in another jurisdiction to be able to decide this particular motion concerning Halligan's appointment. This judge also, Judge Currie, decided Letitia James's motion to dismiss, granting both without prejudice. You may ask, why without prejudice? Well, Judge Currie did the analysis and relied upon some federal cases that said that you wind back the hands of time and you put James Comey back in the place he would have been before the invalid appointment of Lindsey Halligan. That's the reason why it's without prejudice. But I want you to continue to listen to this episode because it does a deep dive into a pending motion to dismiss based upon violations of the Fifth Amendment, a rule of criminal procedure, and other misconduct that was done by Lindsey Halligan in her presentment of the indictment to the grand jury. And that substantive motion, as well as others, including the fact that the statute of limitations has since passed, those may be revived and back in action if the DOJ stupidly tries to re-indict James Comey again. And let me be clear, if that happens, there's going to be a flurry of legal motions and activity that's going to occur. But in this instance, take a listen, because this motion to dismiss for the misconduct with the grand jury and violations of the Constitution, this would actually be a motion that would be granted with prejudice.
So you got to hand it to James Comey. He has dropped a bomb of a motion to dismiss. I mean, he's filed other motions to dismiss that we know about, right? For vindictive and selective prosecution and for the unlawful appointment of insurance lawyer Lindsey Halligan, yet another Trump law lackey. But the motion to dismiss that Comey filed late Friday is so chef's kiss, work of art, legal filing that we got to walk through it in detail. But there's something that popped up in the government's own filing that came in Lindsey Halligan's hurried attempts to defend the shit show that was the grand jury presentment that she did incompetently, that she did poorly, that she did like a ditz. There's something in that I want to highlight for you in just a couple of minutes that you're going to find to be intriguing. Alrighty, so let's walk through this motion to dismiss because it's a doozy in a great way for James Comey. And it really kind of clearly articulates what's at stake here. Because this case has taken a life of its own, but it started with the return of an indictment by a grand jury. And that is how the rules and the law require these cases to begin when it comes to federal felonies, right? It's this idea that the government has to make a presentation to a otherwise fair and impartial group of people that are sitting in the capacity as grand jurors, and they consider the evidence as presented by the prosecution, and then they decide whether or not they're going to return what we call a true bill, which is an indictment. Sometimes they say no. Sometimes, in some instances, they say yes to maybe one or two counts or offenses, and maybe yes to others. But that's how this process gets started. And when it's fatally flawed from the beginning, as has now been argued by Comey's defense team, it takes the entire train off the tracks. And so it's worthwhile spending some time looking at the specific facts as they deal with James Comey's case, because it's incredibly illuminating and enlightening. Alrighty, so here we go. Basic concept of criminal law. A grand jury may indict only if at least 12 jurors concur. That's Federal Rule of Criminal Procedure 6 subsection F. But here, as in the Comey case, at least 12 jurors did not concur in the operative 2-count indictment, and the grand jury rejected the only indictment that the government presented to it. The government's attempt to prosecute Mr. Comey without a valid indictment of a grand jury violates the Fifth Amendment. In addition, the Comey indictment should be dismissed independently because the government's disgusting and grotesque misconduct before the grand jury merits dismissal. Among other grievous offenses, the government relied on information that it obtained in violation of the Fourth Amendment and the attorney-client privileges, as well as some work product privilege. And there were misstatements of the law that were so egregious and grave by insurance law lawyer Lindsey Halligan that it would be purely logical to assume that those gross misstatements of the law would have confused and misled the grand jurors. Collectively, as Comey's team argues, those violations raise grave doubt that the decision to indict was free from the substantial influence of the government's misconduct, warranting dismissal with prejudice. So as we said, the facts are incredibly important for you to think about when it comes to this motion to dismiss, and it begins on page 7 of Comey's motion to dismiss. So let's check that out. So on September 25th, Lindsey Halligan sought a grand jury indictment of James Comey in the Eastern District of Virginia. And according to Halligan herself, those grand jury proceedings began at about 2:18 p.m. And it has been made explicitly clear that there were no other federal prosecutors present at any stage of the grand jury proceedings on September 25th. Now, who else was present? Well, there was an FBI agent who testified in front of the grand jury. He was the only one who testified on behalf of the government. There were the grand jurors, and there was a court reporter. The court reporter is required to be present to be able to record everything that is going on in the grand jury. Why? Because you've got to make sure that everything that happened was kosher. As evidenced by this Comey case, it's critically important. Outside of the grand jury room, there was a grand jury coordinator who works for the U.S. Attorney's Office as an employee, but they do not go inside the grand jury room. And there was also a CSO, a court security officer, who also, again, does not go inside of the grand jury room. So Lindsey Halligan gets in front of this grand jury and presents one indictment. Let me be clear. It's the original indictment. It had 3 counts, okay? Count 1, 2, and 3. The government has presented, a transcript of those grand jury proceedings and an audio recording of Lindsey Halligan's just stupid presentment to the grand jury. Here's the thing, though. The defense has not yet had the chance to review all of the grand jury materials because there was an objection that was filed to the granting of a motion to be able to see this, and it has not yet been resolved. Now, here's something that perhaps has escaped some people's notice and has not been covered, I think, appropriately in the media. So I want to bring it to your attention because it's really important for you to consider. Lindsey Halligan made it explicitly clear that in order to establish probable cause for count 3 in that 3-count original indictment, she relied exclusively on alleged false statements that were the basis for counts 1 and 2. Stated differently, in order for her to try to prove up count 3, she had to rely upon the facts that were set forth in counts 1 and 2. And don't just take my word for it. The United States government informed Comey's defense team of that during a meet and confer meeting on November 12th of 2025. And then it also identified the 2 statements that were in count 3 as examples of alleged false testimony in opposition to James Comey's motion for bill of particulars. A bill for particulars is an attempt by a criminal defendant to be able to get more information and clarity because in this case, it's pretty unclear what the prosecution was attempting to prosecute Comey for in terms of the alleged false statements. So here's another thing about Halligan's presentation to the grand jury that was just stupid and wrong. Judge Fitzpatrick, the magistrate judge in this case, found that Halligan suggested to the grand jury that Comey doesn't have a Fifth Amendment right not to testify at trial, which is one of the most wrong misstatements of the law that you could ever make in criminal law. Furthermore, Judge Fitzpatrick found that Halligan suggested to the grand jury that they did not have to rely only on the record before them to determine probable cause for those counts in that original indictment. But those grand jurors could be assured that the government had more evidence, perhaps even better evidence, that was going to be presented at trial. In other words, hey, grand jurors, my evidence that I'm giving to you right now, I admit is pretty shitty, but don't worry. if you return an indictment against James Comey, I promise the evidence is going to be much better at trial. The fuck? That's not how things work when it comes to grand juries. It certainly is not how things work when it comes to the prosecution of a defendant in criminal cases. Judge Fitzpatrick also found that materials that were kept and searched in violation of the Fourth Amendment were the, quote, cornerstone of Halligan's grand jury presentation. Halligan referred to those materials in her presentation to the grand jury. The FBI agent referenced those as well because it was clear in the transcript and the audio recording of the grand jury presentment that Halligan elicited extensive testimony from that FBI agent when making her presentment to the grand jury. So here's where it gets even more off the chain. The grand jury deliberated for more than 2 hours. And at the end of that 2-hour deliberation, the grand jury returned a no true bill, meaning it rejected that 3-count original indictment that Halligan had presented to it. The four-persons report said, as the foreperson of the grand jury of this court at a session held in Alexandria, Virginia on September 25th, 2025, I report that 12 or more grand jurors did not concur in finding an indictment in this case. The foreperson signed and dated that report, which is appended as a cover page to the 3-count indictment that the grand jury had rejected. And I'm going to show that to you now because I want you guys to be able to see it, right? Because this is really important. If you look at it, it says it very clearly, what I just read to you, right? It says exactly what I just read to you. It's signed by the foreperson whose signature has been redacted for confidentiality. And I don't want you to look at that handwritten in language count one only yet. But check it out now and consider what it says, right? Fine. So, at some point, Lindsey Halligan and the foreperson, they signed the last page of the report of the grand jury's failure to concur in indictment, but then someone from the U.S. Attorney's Office printed out a new indictment that only had 2 counts in it. Count 1 of the new indictment corresponded to count 2 of the original indictment. Count 2 of that new indictment corresponded to count 3 of the original indictment. Halligan and the foreperson signed that new 2-count indictment, but here's the thing. There is 0 record of the grand jury ever seeing that new 2-count indictment, let alone voting on that new 2-count indictment. At 6:47 p.m. on September 25th, Halligan and the foreperson appear before Judge Valla, who was the duty judge that day dealing with the returns of indictments from grand jurors. They gave both of the freaking indictments to Judge Valla. Judge Valla's like, what in the actual hell is going on? I've got 2 indictments here, and I don't understand. This is really unusual what's happening. Halligan's like, I never even saw that other indictment. What are you talking about? And Halligan's like, I only signed the 2-count indictment. I don't know which one with the 3 counts that you have in your hands, Judge. And the judge is like, yeah, but it has your signature on it. To which Halligan says, okay, well, and that's literally from the transcript. The judge then instructed the foreperson to write in count 1 only, that handwritten stuff that you saw, right? And that is why you see the handwriting. That's from the foreperson herself. So, what ends up being the actual indictment in this case? Well, that's the basis of this motion to dismiss, right? Because if you look at the indictment that you're seeing on your screen right now, that's the 2-count indictment. It has different font. It looks like it's been cobbled together if you look at page 1 and page 2. And it does have a foreperson signature and Lindsey Halligan's signature, but here's where the law says that that 2-count indictment is an invalid indictment. Number 1, the transcript is allegedly complete in this case. And this is where I want to bring up an exhibit that was attached to the government's recent filing that I think is a doozy of a doozy for you to look at. So let's check that out now because I think this is important. So check this out. This is an exhibit that was attached to the government's attempt to be able to clarify what the hell happened with that 2-count indictment. And they're trying to save Lindsey Halligan's ass by making this filing. But check out this exhibit. This is an email that was sent from the court reporter that was dealing with the grand jury that day on September 25th. And it was sent to, obviously, somebody that's, I think, within the U.S. Attorney's Office. But it ultimately was forwarded to Lindsey Halligan and those rented federal prosecutors that came from another office because Lindsey Halligan wasn't competent to handle the shit by herself. So check it out though. November 17th, 11:43 a.m., subject follow-up. Good morning, redacted, to whom this was sent. We went back through the audio and transcript for the JC, the James Comey case again, and can confirm that no audio was missed and no testimony was left out. Check this part out. There was one instance where the prosecutor had technical issues with Elmo and some of the jurors assisted and blank came in to assist as well. That is detailed out in the transcript. Let's stop right there. The Elmo is a projector that is used in courtrooms sometimes. It's a type of courtroom technology. And pretty much it's kind of like what you would see when you were in school, when you were growing up. You would put a document face down and then it would be projected onto a screen and you can write on the document, you can highlight the document, you can point to things on the document. And apparently Lindsey Halligan was so fucking stupid she could not operate the Elmo in the grand jury room. So fucking stupid that the jurors, the grand jurors, had to assist her, and then someone whose name is redacted had to come into the grand jury room to help with her to be able to use the Elmo. Okay. When the prosecutor finished presenting her case, she and the court reporter left the room to let the jury deliberate. It was about 2 hours. The court reporter and the CSO, the security officer, remained in the grand jury area outside the jury room. When the deliberations were finished and the jurors were released, the court reporter went back into the jury room, transferred the audio files and annotations to the envelope, and brought it to our offices. The length of the audio files matched the timestamps and the annotations, and nothing was missed or otherwise left out of the transcript. That is critical, people. It just goes to show that there was zero evidence that 2-count indictment, that second one that someone at the U.S. Attorney's Office cobbled together, it was ever presented to the grand jury. And the reason why that becomes a critical issue in this case is, as James Comey clearly articulates here, the failure to present that 2-count indictment, let alone to be able to get the grand jury to approve or veto that 2-count indictment, means that the case should be dismissed. Why? Because that operative indictment, those 2 counts, were never approved by the grand jury. The Federal Rules of Criminal Procedure, Rule 6, makes clear that a grand jury may indict only if at least 12 jurors concur. At this point, you only have a representation made by the grand jury foreperson that the jury had, quote, considered 2 counts. Which 2 counts? What 2 counts? In what capacity? It's actually not very clear, okay? Furthermore, the 12 jurors did not concur in that 2-count indictment because it takes 12 jurors to approve the actual indictment, not the one that was cobbled together after the grand jury had basically been dismissed, right? So, to the extent that any attorney for the government presented the new 2-count indictment to the grand jury, that presentment was apparently not recorded, which also violates a rule of criminal procedure, 6 sub E1, that requires that all proceedings be recorded by a court reporter or by a suitable recording device. But I just read to you the representations by the court reporting agency that there is nothing missing, either audio or transcribed, right? To the extent someone else presented that new 2-count indictment to the grand jury, it's unclear who that person was, what instructions were given, as in what was the law, which is why only attorneys that are authorized by law to conduct proceedings may present to the grand jury. And then who was the experienced legal advisor that explained those 2 counts, how they work and how the law works vis-a-vis those 2 counts to the grand jury? You and I both know the answer to these, right? It was never presented. There is no way that a grand jury looked at that new 2-count indictment, let alone 12 grand jurors returning a vote on those 2 counts. The DC Circuit case law also says that the signature of the foreperson cannot in and of itself convert an indictment admittedly not seen by the full grand jury into one properly found by 12 jurors as required by Rule 6 of the Criminal Rules of Procedure. Now think about this, right? If that happened in this case, the indictment is invalid, this operative indictment. The government cannot continue on this indictment. And the 5-year statute of limitations ran on Comey's alleged offenses on September 30th of 2025, right? And talk about how close the decision was. I want to remind all of you, the grand jury deliberated for more than 2 hours. 2 hours on a 3-count indictment, right? of alleged false statements made by James Comey, issued a no true bill after those 2 hours, and there were fewer than 12 votes for one count and only 14 for the other two. Doesn't sound like some very strong case that was presented, even when dumbass Halligan gave gross misstatements of the law, converting burdens of proof and distorting all prior precedent. Law that is legion, that deals with Fifth Amendment protections for criminal defendants and burdens of proof that are supposed to be carried by the government. Even with those gross misstatements of the law, they still were only able to get barely 14 grand jurors on 2 of those counts. The only remedy that's going to deter this type of egregious government conduct is dismissal with prejudice. It's pretty obvious. Felon Trump initiated this prosecution by way of law lackey Halligan because he wanted to go after Comey because he just wanted to see Comey fry, right? But in this instance, as Comey's lawyers set forth here, the judiciary is a vital bulwark against this administration's intolerable abuse of executive power. It should fulfill that role by dismissing this profoundly unjust and unconstitutional prosecution with prejudice. The Comey defense team has set this one up, teed it up for a home run by the judge in this case, Judge Nachmanoff. Judge Nachmanoff is going to rule on this motion to dismiss, and he is going to rule on other things, but specifically, the Judge Nachmanoff is the person who's going to decide this. When it comes to Judge Fitzpatrick's findings, remember those 11 reasons why Lindsey Halligan fucked up this prosecution? That has been going back and forth. And that was the basis for Judge Fitzpatrick stating that the entirety of the grand jury materials and records should be turned over to Comey. Nachmanoff did a temporary stay on that, saying, let's resolve the objections, because if you'll recall, the magistrate judge sits in conjunction with the federal district court judge. The magistrate judge, Judge Fitzpatrick in this case, makes a decision, enters an order, and that can be appealed to the district court judge, and that's kind of what's happened here. Judge Nachmanoff says, I am going to rule on the papers, meaning just on the filings that have been done by the government and Comey's defense team. So we should get a ruling imminently from Judge Nachmanoff as to the turning over the entirety of the grand jury materials to Comey's defense team. But I'm going to refresh your recollection here. A jury trial has been scheduled for January 5th, 2026 at 9 a.m. Come hell or high water, folks, that ish is going to happen. And importantly, another thing for you to consider is this. There is a court order that has been entered in this case, and it is made explicitly clear that there is not going to be any other delays. There is one other upcoming deadline for purposes of motions in this case. I was looking for the deadline. It's coming up in December, and then that's it. This case is set for trial. So one of two things is going to happen. Judge Nachmanoff is going to dismiss this case outright for any one of the motions that have been filed by James Comey, or it's going to go to trial on January 5th. And if there was ever a case that was ripe for a not guilty verdict, it's this one. You know, thanks for writing this out with me, because I think, again, it's important to look at the facts, the timing, the law, and to also see that everything in this case militates toward a dismissal. Everything in this case militates towards a finding that Halligan screwed the pooch when she made her grand jury presentment. She didn't have the experience, and she was only doing it at the behest of Trump. These are the types of cases that are classic textbook examples of cases that we would be learning about in law school as lawyers, as what not to do. Just flip in the page in those law school textbooks to shit not to do. Put Lindsey Halligan's picture, right? And just put the James Comey prosecution there. Be mad, be outraged, demand accountability. And listen, if there was anybody who deserves to be held accountable for her wrongdoings, including prosecution, it's Lindsey Halligan.
Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.